I'm a police instructor and trainer. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, ICAC, firearms, a whole list of different law enforcement missions, topics, and disciplines. And undoubtedly, the question I get the most, at least from everyday citizens and from law enforcement as well, is the exception to the written warrant requirements. I get questions from citizens all the time in which they think that searches are without probable cause or even without a warrant is against the Constitution. So there seems to be a lot of misconception about warrants, probable cause, and when an officer may search somebody. And a lot of this comes down to just understanding the venue, the case law, and then understanding what is considered a search and what is not considered a search. Because in many aspects, there are a lot of exemptions to the Fourth Amendment that may not necessarily be a full-on search, right? And so we're gonna talk about that. And the reason why I'm making this video, especially in this format, is because I get this question so much from people that at this point, I think what I'm going to do is I'm just going to have this video that I can just link to people and say, hey, instead of going through this entire video, what we're going to talk about, here's the link, take a look at it, decide for yourself essentially, because you're never going to appease everybody. And no matter what evidence you give them, no matter what they research themselves, if your mind's made up, your mind's made up. My job is not here to change your mind. My job here is to give you the applicable facts, case law precedents, and hey, you go out in the real world and you make your own decisions, right? So let's first talk about the Fourth Amendment and what the Fourth Amendment says. So the Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. That's straight from the Constitution, the Fourth Amendment. Now, the next thing that we have to understand is we have to understand exactly how our government works, and we need to understand basically the three arms of government and how they interplay. So we have to understand that there's three: the legislative, the executive, and judicial. The legislative branch makes laws, approves presidential appointments, 2 senators from each state, the number of congressmen is based on population. Then we have the executive branch, signs laws, vetoes laws, pardons people, appoints federal judges, and is elected every 4 years. Then we have the judicial, decides if laws are constitutional, are appointed by the president. There are 9 justices, and they can overturn rulings by other judges. They're also known as the court of last resort, because when Supreme Court precedence is made, it is final. They have, again, court of last resort. They get to make the decisions on how case law precedents will go. And so understanding this, we have to now understand exactly, now that we understand this exactly, we understand that the way our system of government is set up, that the case law and the Supreme Court precedents is going to dictate the adherence to standards and how law enforcement shall perform the functions of their duties. So the next thing we have to talk about is, are there any exemptions from the written warrant requirement? And there are 8. So the 8 exceptions from the written warrant requirement are: 1, search incident to arrest, Chimel versus California, 1968. Next, probable cause with exigent circumstances, Arkansas v. Sanders. Then we have probable cause search of motor vehicle, Carroll versus United States, also known as Carroll Doctrine, 1925. And then you have inventory searches, South Dakota v. Opperman, 1976. Then you have valid consent, Florida versus Gimeno, 1991. You have open fields, also known as Open Fields Doctrine, Oliver v. United States, 1984. You have abandoned property, Abel versus United States, 1960. And you have Plain View Doctrine, Coolidge versus New Hampshire, 1971. So let's dig a little bit deeper into this. So let's talk about search incident to arrest. Again, this is found in Chimel v. California, 1969. The Supreme Court held that police could reasonably search and seize evidence upon and around the arrestee's person's immediate control, immediate reach. in his home without a warrant. However, the Supreme Court held that the police could not search the entire home without a search warrant. So what does this mean? This means that if you are lawfully arresting somebody because you have probable cause, you're lawfully making an arrest, you can then search everything upon that person in the performance of that arrest, in the performance of that seizure. So this would be, again, an exemption to the written warrant requirement. Now let's talk about exigent circumstances. So the Supreme Court, again, has identified and affirmed exigent circumstances. And those would be those circumstances that would cause a reasonable person to believe that entry or any other relevant prompt or action was necessary to prevent physical harm to officers or other persons, to prevent the destruction of relevant evidence and the escape of a suspect, or some other consequences that would improperly frustrate legitimate law enforcement efforts. Again, and that's found in United States v. McConley, 1984. Now let's talk about probable cause searches in vehicles. So an officer who has legitimately stopped an automobile and has probable cause to believe that contraband is concealed somewhere within it may conduct a warrantless search of the vehicle as thorough as if a magistrate judge could authorize by a warrant. And again, you're going to find that in Carroll v. United States, 1925, Bengar versus United States, 1949, United States v. Ross, 1982, California v. Carney, 1985, and California v. Essendo, 1991. Let's talk about vehicle inventory searches. So the Supreme Court, again, has affirmed and upheld that the Fourth Amendment does not prohibit the state from proving the criminal charges with evidence discovered during an inventory search of a respondent's motor vehicle. Now, there are certain reasons why a vehicle may be towed. There are state statutory reasons, whether that's suspended license, failure to have insurance, not registering their car in the state in a timely manner. There are several registration acts, etc. And so the Supreme Court, again, has upheld that the Fourth Amendment does not prohibit the state from proving criminal charges with evidence discovered during an inventory search of a respondent's motor vehicle. And that's South Dakota v. Opperman, 1976. The Supreme Court held that police may open closed containers while conducting routine inventory searches of an impounded vehicle. The United States held that the importance of having such inventories conducted only pursuant to standardized police procedures. The underlying rationale for allowing an inventory exemption to the Fourth Amendment warrant rule is that police officers are not vested with the discretion to determine the scope of the inventory search. This absence of discretion ensures that inventory searches will not be used as a purposeful and general means of discovering evidence of a crime. Therefore, it's permissible. Again, South Dakota v. Opperman, 1976, Colorado v. Bernstein, 1987, and Florida v. Wells, 1990. So let's kind of dive in a little deeper when it comes to inventory searches and inventory policy. Because at the end of the day, if the vehicle is going to be impounded for something not relevant to what may have been discovered in the search. So let's say the person is a convicted felon, and in the inventory search, there is a loaded firearm that is found under a seat, in a glove box, wherever it might be found in the vehicle. The discretionary objective of the officer was not to find the crime. The officer had no discretion because the officer is inventorying the vehicle due to policy. The policy states if you're going to tow this vehicle, you shall conduct a tow inventory, and this is how you shall conduct it. So the officer no longer has discretion on how he's going to inventory that vehicle. The inventory has to be done in a standardized way. And the reason, hence, this is important is because of the tow vehicle inventory elements, right? So when a vehicle is impounded by local police departments, they generally are going to follow a practice of securing and inventorying the automobile contents. These procedures were developed in response to three distinct needs. One, United States v. Mitchell, 1972, the protection of the owner's property while it remains in police custody. Number two, United States v. Kelhar, 1972, the protection of the police against claims or disputes over lost or stolen property. And number three, the protection of the police from potential danger. Cooper v. California. The practice has been viewed as essential to respond to incidences of theft and or vandalism. And again, these elements are found directly in the Supreme Court case precedents we just talked about, South Dakota v. Opperman, 1976. Now let's talk about valid consent. So in Florida v. Gimeno, 1991, the Supreme Court again held and affirmed that the Fourth Amendment right to be free from unreasonable searches is not violated when a defendant gives police permission to search his car. They may open closed containers they find within the car that might reasonably hold the object of that search. The amendment is satisfied under the circumstances. It is objectively reasonable for the police to believe that the scope of the suspect's consent permitted them to open particular containers. Here, the authorization to search extended beyond the car's interior surfaces to a bag, since Gimeno did not place any explicit limitation on the scope of the search and was aware that the officer, Trujillo, would be looking for narcotics in the car, and since a reasonable person may be expected to know that narcotics are generally carried somewhere in some form of a container. There is no basis, again, the Supreme Court states and affirms, there is no basis for adding the Fourth Amendment basic test of objective reasonableness as a requirement that if a police officer wishes to search a closed container within the car, they must separately request permission to search each and every container. So again, what does that mean? It means if you give a police officer consent to search your vehicle, they may search the vehicle. Again, I think that goes without saying. So if you give an officer consent to search for something, you were saying, okay, you can search for the thing that you're looking for. Now let's talk about open fields doctrine. So open fields doctrine has been affirmed by the Supreme Court. The Supreme Court states and affirms that individuals cannot legitimately expect privacy for activities conducted out in the open except in the immediate area surrounding their house or curtilage. Also, the act of the police officers entering a privately owned field is not automatically a search for Fourth Amendment purposes, even if it's common law trespass. So again, this is open fields doctrine, and this is going to be found in Oliver v. United States, 1984. And we're also going to find the initial case in Hester v. United States, 1927. Let's quickly talk about abandoned property. So in Abel v. United States, 1960, a petitioner named Abel was arrested on an administrative immigration warrant. After he had checked out of his room and left, there were certain articles that were left behind that he did not bring with him. An FBI agent then, with the consent of the hotel management, went into the room that Abel had already checked out of. He then seized certain articles that were in that room and then brought it up in trial. Obviously, they went to suppress that seizure. They went to suppress that search on abandoned property. But again, the Supreme Court held and affirmed that these searches do not violate the Fourth or Fifth Amendment, and the use in evidence of the articles so seized did not invalidate Abel's conviction. Again, Abel v. United States, 1960. Let's talk about plain view doctrine. The Supreme Court has affirmed that the legal principle that if a police officer is lawfully in a position to see an object that is clearly evidence of a crime, they can seize that object and use it as evidence even without a warrant under what is known as plain view doctrine. And this is pursuant to, in accordance with, numerous Supreme Court case precedences to include Harris versus United States, 1968. INS, Immigration and Naturalization Service versus Dialgo, 1984. Horton v. California, 1990. And Collins versus Virginia, 2018. So now that we've talked about what law enforcement experts, trainers, instructors call the 8 exemptions to the written work requirement, let's talk about other nuances that we find within criminal justice, within law enforcement, that don't necessarily apply to the exceptions that we talked about earlier. So the first one that I would mention, because again, this is layered and nuanced, would be what's called CTF. CTF is known as Community Caretaking Function. Now, this is a doctrine. This is called the CTF Doctrine, and this is recognized pursuant to, in accordance with, Supreme Court case precedents Caddy versus Dombrowski, 1973. And so this is what that Supreme Court case precedent states, that the CTF doctrine is one that recognizes that police officers are a jack of all emergencies who are expected to aid those in distress, combat actual hazards, prevent hazards from materializing, and provide an infinite variety of other services to preserve and protect community safety. The courts describe this police function as community caretaking. And this is when an officer acts totally divorced from the detection, investigation, or acquisition of evidence relating to the violation of a criminal statute. They act within their capacity as a community caretaker. This is important because these actions are considered an exemption to the Fourth Amendment protections against unreasonable searches and seizures, Caddy v. Dombrowski, 1973. So let's talk about another nuance that's found within Supreme Court case precedents. This is known as the emergency aid exemption. The United States Supreme Court held that police may enter a building without a warrant when they have an objectively reasonable basis to believe that an occupant is seriously injured or threatened with such injury. Quoting from Mincy v. Arizona, Chief Justice John Roberts wrote that the need to protect or preserve life or avoid serious injury is justification for what would otherwise be illegal, absent an exigency or emergency. Again, this is known as the emergency aid exemption, and this is found in pursuant to, in accordance with, Brigham City versus Stewart, 2006. So let's talk about administrative searches. Well, pursuant to, in accordance with, Illinois v. Lafayette, 1983, the Supreme Court again has held and affirmed that it is reasonable for police to search the personal effects of a person under lawful arrest as part of the routine administrative procedure at a police station incident to booking and jailing the suspect. The justification for such searches does not rest on probable cause, and hence the absence of a warrant is immaterial to the reasonableness of the search. Here, every consideration of orderly police administration, to include the protection of a suspect's property, deterrence of false claims of theft against the police, security, and identification of the suspect. Therefore, this search is benefiting both the police and the public and points towards the appropriateness of the examination of the respondent's personal effects, again, pursuant to, in accordance with, Illinois v. Lafayette, 1983. So let's talk about stop and frisk. Let's go a little deeper. So the Supreme Court has affirmed in Terry v. Ohio, 1968, that if a police officer has reasonable, articulable suspicion to believe that an individual has a weapon which poses a danger to the officer may stop the individual and perform a stop and frisk, or what other people would call a limited search for weapons. The Supreme Court has found that searches undertaken were limited in scope, the stop and frisk, and were designed to protect the officer's safety, incident to the investigation, and they were found permissible. Let's go even deeper with it. Let's talk about plain touch doctrine. The Supreme Court unanimously held that if a police officer who is conducting a lawful pat-down search for weapons pursuant to, in accordance with, Terry v. Ohio, 1968, and that officer feels something that is plainly contraband, the object may be seized, even though it is not a weapon under very specific conditions. This is known as plain touch doctrine, pursuant to, in accordance with, Minnesota versus Dickerson. Law enforcement that are engaged in a lawful activity and discover something that is immediately apparent to be evidence of criminal activity may be seized. Again, Minnesota versus Dickerson. So as I've demonstrated with the aforementioned Supreme Court case precedences, it's abundantly clear to me, and it's abundantly clear to the people who study this, and it's abundantly clear based upon the precedents set forth by the Supreme Court that there are many reasons why a police officer would conduct a search without a written warrant. And so, again, I want to bring this back full circle and bring us back to the Constitution, and I want to bring us back to the way the Constitution has set up our government. Again, this three arms of government, because we have to realize that everything that we see and everything that is ran by humans. And are humans fallible? Yes. Am I sitting here telling you that I agree with every Supreme Court case precedence? No, I'm not saying that. But what I'm saying is I also have to live in reality. And the reality is that the judicial arm of government gets to decide, the Supreme Court, the court of last resort, gets to decide if laws are constitutional. And that is founded in our founding documents. That is how the framers, that is how the people that wrote our Constitution, that is how our forefathers, our founding fathers of this country and this nation, that's how they wanted it. They wanted three arms of government, the legislative, the executive, and judicial. And they enumerated powers to the judicial. And they allow the judicial arm of government to decide what is constitutional. Again, they are appointed by the president. There are 9 justices, and they can overturn rulings by other judges. Whether you like it or not, again, this is not my opinion. This is simply the facts that I'm presenting to you based upon the already aforementioned Supreme Court case precedences. I'm not saying you have to like it. I'm not saying you have to agree with it. My only job in this video is to give you the reality and allow you to make your own decisions. Long live the Republic.